We're talking today to Professor Brandon Garrett, the author of Too Big to Jail. Welcome to Redera.
Thank you. Thank you for having me.
What is the book all about? And obviously, corporations are not same as the individuals, and how the American regulators deal with corporations sometimes differently than individuals.
So I think people are used to the idea that corporations can be persons for some purposes. A lot of people are familiar, say, with Citizens United, where the Supreme Court said that corporate persons have First Amendment speech rights to donate money to political campaigns. But there is a flip side to corporate personhood. Companies, as an artificial entity, have certain legal protections and rights, but they also have obligations and responsibilities. And one consequence of that is that if employees at a company commit a crime, the company itself can be held criminally responsible. That doctrine goes way back to an old Supreme Court case in 1909, where the Supreme Court said that basically for practical reasons, it often makes sense to hold the company accountable for the crimes of employees. Since employees often do things to help the corporation profit, maybe it makes sense for the corporation to then have to give up those profits and pay the fine. So companies, when they get convicted of crimes, typically, obviously they can't literally go to jail. Companies cannot be jailed, which is why the title is in part humorous. But companies can pay a fine. They can also cooperate with the authorities to help prosecutors identify which people committed crimes so that those people can be investigated and charged. Companies can also do other things. They can try to fix their practices so that crimes don't happen in the future. So there are a number of goals when you prosecute a company. The goal is to get it to make the victims whole, pay a fine, help to investigate who did wrong, and hopefully improve the company so that the same thing doesn't happen again.
There have been a number of high-profile cases, especially in the last 10, 15 years. So rarely do you see individuals responsible or the executive management at the company ever suffer personal consequences or ever go to jail. Are there different standards in many of these prosecutions are never even recorded? They don't even make it to the court. And some of them are called non-agreements or deferred agreements, and there are all kinds of labels they come up with it, but they have a different way of dealing with a corporation.
Yes, and there's a little bit of a history to that. So before the 1990s, you typically didn't see federal prosecutors go after corporations. And you'd expect it to be the federal prosecutors that do it because those offices have more resources. A lot of the more complicated white-collar cases, financial crimes cases, they often get brought by federal prosecutors and not by our local prosecutors. There's some exceptions. In New York, for example, the district attorney's office and the state attorney general, since they preside over Wall Street, they often bring more complicated financial cases. But in general, you would look to the federal prosecutors. And one reason that federal prosecutors didn't bother going after corporations too often, at least, was that you couldn't get much of a sentence out of a corporation any different than the individual. That changed in the early 90s. In 1991, the Sentencing Commission passed organizational sentencing guidelines. This is a new concept, the idea that you would sentence a company differently. And part of the idea was, the company can really make the victims whole. If it's like a $100 million fraud scheme, the particular employees, they're not going to be able to come up with $100 million, but the company can. And so you can deter really big corporate crimes by finding a company different than you would an individual person. Starting in the 90s, prosecutors at the federal level started bringing more cases against the company because all of a sudden there was a reason to do it, and you could get big sentences. And by the late 90s, you started to see $10 million cases, $50 million cases. Then you had the scandals that came out of the Enron era, and prosecutors went after Arthur Andersen, the Big Five accounting company. They were worried about convicting Arthur Andersen because if they did, the Securities and Exchange Commission might say that Arthur Andersen couldn't work with public companies anymore. And a Big Five accounting firm, that's their lifeblood. The accounting firm would go under if they did that. And they didn't want to destroy Arthur Andersen, so they offered Arthur Andersen something really unusual, something that had only been done maybe 8 or 10 times in the 1990s. They said, we'll give you a deferred prosecution agreement, an out-of-court deal, where if you agree to pay fines and accept responsibility and cooperate, we won't seek a conviction because that could be devastating for you. Arthur Andersen turned down the deal. And one reason was they weren't sure whether the SEC might take away their privileges regardless, since they're under investigation for lots of other things not related to Enron. There are all kinds of accounting misstatements that were coming to light in 2000, 2001, after the dot-com bubble burst. And so Arthur Andersen goes to trial. They raise all kinds of defenses. They say, we're not, who is obstructing justice? No one told us to shred the documents. We were just shredding them to be careful. They tried all sorts of arguments. They got convicted of obstruction of justice for shredding all kinds of documents relating to Enron. And the SEC promptly took away their privileges to work with public companies, and Arthur Andersen was destroyed. It dissolved. After that, prosecutors may have been right, and they tried to offer a deal. But after that, prosecutors were much more careful about prosecuting sensitive companies, and especially big companies like Arthur Andersen, public companies. They adopted new guidelines in 2003, which encouraged the use of these deferred and non-prosecution agreements, where you don't try to convict a company, you offer them a deal to avoid an indictment and a conviction. And the concept was really unusual. Normally, you don't give an out-of-court deal to serious criminals. They give those deals, which are often called diversion, as an alternative to the regular criminal justice system, usually to like first-time offenders, maybe a first-time drug user. You go to treatment. If you pass your drug tests for a year, we'll drop the charges. To do that for the biggest corporations and the biggest corporate crimes was a creative move and a big change. But what we saw was starting in 2003 or so and continuing to the present, many of the biggest corporate criminal cases were settled this way, mostly out of court through these deferred prosecution agreements, sometimes through these non-prosecution agreements where nothing is even filed in a court at all. And there were some good things about that strategy. More and more cases were brought against really big companies. The fines skyrocketed. You never saw billion-dollar fines in corporate criminal cases before. But there are also some downsides of this. You mentioned individuals getting charged, and it was only about a third of the time that any individuals were charged in these cases. What it seemed like was that prosecutors were getting big dollar amounts, big fines, but the cases were handled informally out of court, and they typically didn't result in any individuals getting investigated and charged.
In the book, you go at quite a bit of length in describing what happened with Arthur Andersen and also with Enron cases. In case of Enron, there were some serious gross oversights and misstatements and intentional fraud, to say the least. But the shareholders or the people who lost the money, they were never compensated, even when those fines were collected. Somehow what I've noticed is that over the years there are more and more fines levied and collected, but the shareholders or the people who should be getting the money back to them, they never receive it.
Yeah, so there's a real question of, what good does it do to impose huge fines on a company? Sometimes the shareholders or the victims really do receive some of that money, and prosecutors often create these victim restitution funds, or they use forfeiture to return money to victims. And so where there are identifiable victims, actually prosecutors are required to seek them out and try to compensate them. It's not always easy to do that, but there's a separate concern that if you impose big fines on a company, the people who committed the crimes obviously don't pay that. And they don't necessarily suffer any direct consequences. Maybe the company would fire them, and sometimes companies do. But if they're not criminally charged, if there's no sanction imposed on them, then it's the shareholders who pay for the crimes. That's a big concern. And prosecutors, they know it. One response they have is, we try to investigate individuals when we can and hold them accountable, but it's not always easy to do, and it's really expensive and challenging. Another response they have is, we want to make sure that there is accountability going forward, and that's why we require companies to do compliance. We bring in independent monitors to supervise companies to make sure that they change all their procedures, do auditing so that these frauds or whatever the crime is so that it can never happen again. And there I also talk in the book about how a lot of these agreements actually aren't particularly rigorous at all about the compliance aspect, that they tell the company to do some best practices. They actually bring in monitors pretty rarely. And the idea that you can shape up a huge company that's committed huge crimes in a year or two seems kind of laughable, but often these agreements are very, very short, and there isn't a lot that goes into thinking about how to make sure it doesn't happen again. And then there's an even more disturbing consequence that you have companies that have been prosecuted multiple times, time and time again. They're recidivist companies. And there you start to really wonder whether these prosecution agreements are really doing much to deter or prevent crime.
Oftentimes they're asked to do more compliance, but they're never asked to follow a certain procedure or see whether they are doing well with the compliance or not. They just tend to be very vague.
Oh, and one way to make sure that a company is more accountable is to enter agreements that are not informal, that are not out of court, but to actually have it in front of a judge. And for, when individual people like us are convicted of crimes, people get put on probation and they have to report to a probation officer. If there's any, even sometimes pretty minor breaches, like not showing up for a meeting on time, there can be really serious consequences, like going back to jail. If a company is convicted, it can be put on probation too. And if it's not doing the compliance that it's supposed to be doing, and a judge can have special masters watching over the company, then there could be severe consequences for a breach. Plenty of companies are put on probation and are convicted every year, but a lot of the biggest companies are now getting these out-of-court deals. And that's why I think there's something useful about having a company get convicted, have a criminal record, and then get put on probation. Now, I'm not sure that our regular probation officers are really qualified to supervise corporations. We might need like a special Department of Corporate Probation. But judges can also appoint special masters. They can have outsiders who are experts get paid by the company to do this kind of supervision. We are starting to see the Department of Justice respond to some of these criticisms. And in some of the big, including cases involving banks, some of the big cases in the last couple of years, they've started to say that we're not going to give you a deferred prosecution anymore. We want a conviction. We want the more serious consequences that come with a conviction. And I'm glad to see that the Department of Justice is starting to respond to some of these concerns. And it's changing the way that it brings some of these corporate prosecutions.
We had a very unusual financial period during the economic crisis and the financial crisis. How did prosecutors dealt with the banks? Of course, we know that there were no criminal charges, so there was nobody convicted. But looking back now, in the hindsight, do you think there are different things that could have been done in how these corporations were saved? But were there any better behavior related elements were put in place as well?
Obviously, you can't use criminal prosecutions after the fact to substitute for better laws and better regulations. And so if there are risky things that banks were doing that contributed to the financial crisis, if there are industries that have risky behavior which allows crimes to happen, you can punish companies that break the law. But it's much better to have good laws in place in the first instance. And it's much better to have a safe speed limit than to prosecute people for vehicular manslaughter every once in a while where a driver does something terrible. You want to have good rules of the road in place. And so there is a concern that you just can't use criminal prosecutions to substitute for sound regulation. What these prosecutions can do is that make sure that there aren't really egregious lawbreakers out there. And hopefully that's what they will do going forward. But there's also a concern that sometimes after a big corporate scandal or crisis, that one of the responses is, well, let's raise the sentences for fraud. Let's put the guys in jail. And it's obviously very important to hold corporate criminals accountable, but you can't let the impulse to punish get in the way of the impulse to actually make sure that good laws are in place so that those kinds of crimes don't occur.
In the book, you have a chapter titled The Carrot and the Stick. What is the carrot that they hang, and what is the stick that they have? They obviously have a big stick that they carry because of various statutes they have.
The way that companies are punished under the sentencing guidelines is intended to both reward good corporate behavior and to punish bad corporate behavior. And in any criminal case, prosecutors do cut breaks for some criminal defendants. One of the main ways you can get a lower sentence in the federal system is to provide substantial assistance and help prosecutors identify the other culprits. Cooperating witnesses can get a break. Informants can get a break. With companies, it's a little odd to think of the company as an informant, but the company really is a remarkable source of information since the company has possession of all the emails, all the text messages, all the documents, all the memos, enormous quantities of data that can shed light on who the wrongdoers were. So one of the first things that prosecutors want from a company is its cooperation in identifying who are the wrongdoers. And the sentencing guidelines and just the practices of prosecutors allow and encourage companies to cooperate, and in return, they can get a reduction in the fines. They can get a more lenient result. And that is a good thing. You want companies to cooperate. You also want them to self-report, because one thing that makes corporate crime, sometimes at least, unique is that, particularly with financial crimes or frauds, the whole nature of a fraud is that you're deceiving someone. You're hiding information from people. Hidden information has a way of staying hidden. And so crimes like frauds, it's very difficult for them to come to light. People who are fooled can stay fooled. And so it's not like a street crime like an assault or a murder where everyone knows that a crime happened. we may have no idea that a fraud even occurred. And so it's really important to give companies incentives to come clean, since often it may be people in the company that know that there was a crime, but no one else knows. And so how do you break inside these corporations and find out that something terrible happened, that people were deceived? Well, one way is to encourage that information to flow to the government and to reward a company that comes clean on its own, even if the government had no idea that a crime happened. And so there have been stronger efforts in recent years to give companies credit for coming forward on their own where no one else knew there was a crime, and self-reporting, and then for cooperating with prosecutors and giving them all the information about who did what. The rules also give a company credit for having really good compliance procedures in place. Now, they can't have been that good if there was a crime that happened anyway. But sometimes, if an employee did something really sneaky to bypass all of the protections against committing crimes, you might say that that was a rogue employee, but the company really did have good systems to make sure that it didn't happen, and it's not right to blame the whole company. And prosecutors often do that. They far more often just prosecute individuals. They tend to only go after the company if there's something systemic at the company that explained why a crime happened. So those are all ways of kind of incentivizing good corporate behavior and only punishing the companies that had bad compliance, bad systems, that didn't report the crime themselves, and that don't cooperate once the crime does come to light.
Mm-hmm, mm-hmm. Where do you see the corporate prosecution heading? I mean, there has been a lot of events and a lot of activities, especially since the financial crisis. But do you see any more corrective steps or change in direction or change in strategy coming from the Department of Justice or other prosecutors at state levels as well?
I think it's a really exciting time in the world of corporate crime. Every few weeks we hear about new cases, new investigations, new major settlements of corporate cases. We never used to see billion-dollar corporate fines. Now it's routine to see them every single year. Every year in the last 5 years, we've had new records broken for corporate fines coming out of federal prosecutors. And obviously just imposing money amounts isn't enough, but the biggest cases have gotten bigger and bigger. I've also been really pleased to see, even since my Too Big to Jail book came out, the Department of Justice has been really responding to critics. One of the things I was concerned about when I wrote the book was that so many of these cases are being resolved out of court through these deferred and non-prosecution agreements. Well, one thing the Department of Justice has said in the last couple of years is that they are now willing to seek convictions against the worst corporate offenders, even banks, where they hardly ever did that before. And we've seen that. We've seen some of the biggest cases against banks in the last couple of years result in guilty pleas with convictions for the banks. So that's I think a really good change. The other big change that occurred this last fall was that Sally Yates, the current Deputy Attorney General, a really important position at the Department of Justice, announced a new set of corporate guidelines for prosecutors when they're considering and when they're in the process of charging a corporation. And these guidelines place much stronger emphasis on rewarding a company that comes forward and self-reports a crime. But much more important, the guidelines talk with a lot of detail about changing the focus to individuals. So they say that from the very beginning of an investigation at a company, you're supposed to focus on what individual people committed crimes. And you're supposed to ask for that information from the company, and that you shouldn't just be settling cases with the company if you haven't gotten that cooperation and they haven't identified who did what. And so the idea is to really make the priority holding individuals accountable and not just settling cases with a big fine for the company first and then sort of not bothering with the individual wrongdoers. So we'll see if that policy change pays dividends. Kind of too early to tell right now. But those are big changes, and it's a relief to see that the Department of Justice is really taking criticism seriously, and that this approach towards corporate crime may adapt and answer some of these too big to jail concerns over time.
Mm-hmm, mm-hmm. We have been talking about the book Too Big to Jail, and let's talk a little bit more about the author. How did you get interested in all these legalistic and then teaching part of it as well? Because you're a professor as well. Tell us a little bit more about you as a person and a little bit evolution of your professional career.
I'm a law professor. I teach at the University of Virginia. I've taught here since 2005. Before I went into teaching, after college, I represented actually homeless people and tenants in New York City. I did a lot of work at welfare hearings, helping people who felt like their welfare benefits were being unjustly terminated, people facing homelessness. I helped them put together grants so that they could pay their rent and keep their apartments. And so I did a lot of sort of poverty law work, and I went to law school wanting to be a civil rights lawyer. While I was in law school, I started getting much more focused on criminal justice work, in part because that was at the time when the first big class action cases were being brought challenging racial profiling in New York City. That's been an issue in the news in recent years, but the first class actions were filed in the late 1990s, and I was able to work on those cases during summers in law school. That made me just much more interested in how the criminal justice system works. And after I finished law school and clerked for a federal judge, I worked at a small law firm called Cochran, Neufeld, and Scheck. The lawyers were well-known lawyers, Johnny Cochran, and then Barry Scheck and Peter Neufeld, who co-founded the Innocence Project back in the early 1990s. And some of the cases I worked on there involved cases of people who had been freed by DNA testing and were seeking compensation for all the years in prison that they spent while innocent. And so when I went into teaching in 2005, I was interested in studying criminal justice. I did a lot of work studying wrongful convictions and what causes them. My first book is called Convicting the Innocent, and I tracked the cases of the first 250 people who had been exonerated by DNA testing. I looked at why did they falsely confess, why did the eyewitnesses make mistakes, why did informants lie at their trials, what about the forensics that were in their cases before they got DNA, why were those forensics wrong? While I was working on that wrongful conviction project, a big project, I noticed in 2005, 2006, pretty early on when I was teaching, that there were these deals which looked like complicated civil rights consent decrees being entered between prosecutors and major corporations. And so early on, I noticed that these deferred prosecution agreements were becoming a big deal, and I started tracking them. And I created this University of Virginia website, keeping a kind of a corporate offender registry. And that website took off. Lots of lawyers started to rely on it as a resource. And so at the same time that I was doing this wrongful conviction work, I was tracking really the opposite end of the criminal justice system. Not, poor people who are convicted of crimes of which they were innocent, but the biggest imaginable cases against corporations. And so separately tracking data on these corporate prosecutions. And so finally, a few years after my wrongful convictions book was complete, I turned towards this corporate prosecution data that I've been collecting for so many years and decided that it was worth putting it all together in a book. There is also a website that accompanies the book where people can read for themselves all of the deals entered by prosecutors. You'll see lots of companies that are household names, companies like Google and General Electric and General Motors and Toyota and every kind of company imaginable, Fortune 500 companies, Global 500 companies. You can see all of the deals that they enter with prosecutors. And so, my goal throughout has been to just gather as much information as possible about what's really happening on the ground in these kinds of important criminal cases.
Do you have any other books that you're working on or any other topics that you're covering or deep researching to write the next book?
Yeah, so I'm working on another project which involves collecting a lot of data about something that we don't know enough about. I'm working on a book also to be published by Harvard Press, which published my first two books. It's a book looking at why the death penalty in the United States is declining so quickly. And so it's not about corporate crime, it's about the most serious crimes, the most serious murderers. Only the worst of the worst are supposed to face the death penalty in the United States. But death sentences have dropped enormously, starting in about 1999. It used to be in the 1990s that you'd have 300, 350 death sentences a year in this country. Last year, there were only a little over 50 death sentences. In some of the states that used to be the biggest death penalty states, like Virginia, where I live, Virginia hasn't sentenced anyone to death in 5 years. Now it's going on a little bit more than 5 years. Georgia sentenced no one to death last year. North Carolina sentenced no one to death last year. Even Texas, the leading death penalty state, it sentenced only 3 people to death last year. Something remarkable has changed in this country, and I've been collecting data on which counties sentence people to death, and I've been analyzing the patterns of this decline to try to get a sense of, why is the death penalty declining so quickly in some places and not in others? What accounts for this trend, and whether there are any lessons that we can learn for criminal justice more broadly. Because if the way we handle the most serious murderers can change so dramatically in just 10, 15 years, I wonder, what does that say about criminal justice change in general at a time when we're rethinking a lot of the ways that we punish people in this country? So that book will be out probably at the earliest in late 2017.
Oh, okay. Will this be your third or fourth book, or?
Yeah, this will be my third book.
Third book. Mm-hmm. Now, do corporations continue to enjoy certain constitutional rights that people may or may not appreciate enough when it comes to criminal prosecution or in dealing with regulators or prosecutors?
Well, I think there are a lot of myths about what constitutional rights we have and we don't have in the criminal justice system. And there are a lot of rights which people do have, but which most people don't use. For example, I think everyone has heard of the famous Miranda warnings, but very few people, when they're questioned by the police, ever assert them. People usually just waive their rights and talk to the police. One thing that people really don't appreciate, because we see so many shows like Law and Order where there are criminal trials, people don't realize that almost all criminal cases are negotiated. And so, almost no corporations take their case to trial. Arthur Andersen was the really rare case where there was a corporate criminal trial. The company itself was tried. Incredibly rare for there to be a trial in corporate cases. But you might think, well, those are corporations. They can hire lots and lots of lawyers to work out deals. But it's true of criminal cases involving regular people, too. In general, in the federal criminal justice system, over 95% of felony cases are resolved through plea bargaining. So very few cases go to trial. Almost everything is bargained. And that means it's really important to have a good lawyer. It really matters what the sentencing guidelines say, because if a crime has a mandatory sentence, there's no way or reason for the prosecutors to offer less than a mandatory sentence. It also means that people may think that there's a chance to tell your story and prove your innocence, show the facts. Well, that doesn't exactly happen if there's just kind of a negotiation and prosecutors say, this is 5 years. The guidelines say 5 years. Your lawyer says, well, he says he's innocent. And the prosecutor says, well, take it to trial. But if you go to trial, you might get a lot more than the minimum. You might get 30 years. And so you settle for 5. I think that kind of bargaining that happens in our criminal justice system, rights don't really matter. It's like an administrative process. And people don't see that. Only once someone gets caught up in the criminal justice system do they see how the wheels turn. And it's not a pretty sight.
Mm-hmm. Has there been any other corporation, large or reasonable size, that has been tried under criminal charges since the demise of Arthur Andersen?
There have been a few. So some companies still take their case to trial. In fact, there's a big trial that's about to start right now involving FedEx. FedEx was prosecuted for violations. The prosecutors say that FedEx should have known that packages were being delivered that had illegal drugs in them. And FedEx says, we had no way of knowing. We don't want drugs delivered by FedEx. We're taking it to trial. So we'll see what happens. Some smaller companies sometimes take their cases to trial. There have been some major companies that have taken antitrust cases to trial. And the defense is often, maybe some of our competitors were fixing prices, but we weren't part of the scheme. We were just setting prices the way we always do. Most of the time, those cases result in convictions, and the company is convicted and gets a worse penalty at trial. Although there's one case I talk about in the book where kind of a medium-sized company was charged with foreign bribery, and the judge threw the case out after the trial. And enough evidence came out that undercut the government's case, and the company was victorious. So, sometimes trials really do bring out new information that people didn't realize going into it.
Mm-hmm. We've been speaking with Professor Brandon Garrett, the author of Too Big to Jail, How Prosecutors Compromise With Corporations. Thank you very much for your time and your comments, and please do keep us in mind when you have your new book out there.
Well, thank you so much for having me.
Thank you.